on yet?
Yep, I'm on.
Okay.
It's John Brescher.
Okay. I see John's phone. Got it.
There are a bunch of people waiting. Okay, I'm bringing over Jim right now, Susan.
Okay. Okay, it's 4:01, so I'm just going to start with this, the script for this meeting. Okay. Good afternoon. My name is Susan McCarthy. I am the chair of the Zoning Board of Appeals for the town of Nantucket. Please listen carefully while I read through the participation guidelines and ground rules. Public participation guidelines. We are using Zoom for this meeting. Zoom has the capability to allow the public participation in the meeting as an attendee. Attendees must register using the registration link in the description of the Nantucket Government TV YouTube live feed for this meeting. The registration link is unique to this meeting. To be an attendee, members of the public must use their full name for identification to participate in the meeting. You will not be allowed to participate in the discussion if you do not provide your full name. The town reserves the right to remove any member of the public from the meeting who does not provide their full name or acts inappropriately. Attendees are added in listening mode. To speak, click the raise hand button. The chair through staff will call on the raised hands. The chair and staff will make their best efforts to call on attendees in the order the attendees raised their hand. All questions shall be directed through the chair or the acting chair. Confirming member access. At this time, I will confirm all members, staff, and anticipated speakers on the agenda are present and can hear me. As I stated previously, my name is Susan McCarthy. I serve as the chair of the Zoning Board of Appeals. In the event I have a conflict on an application, Lisa Botticelli, vice chair, or Elisa Allen, clerk, will serve as chair. Members, when I call your name, please respond in the affirmative. Elisa Allen.
Here.
Michael O'Mara. John Brescher.
Here.
Mark Poor. And Jim Mondani.
Here.
Okay. Staff, when I call your name, please respond in the affirmative. Nikki Sheriff.
Here.
And Billy Saad.
Here.
Okay. And anticipated speakers on the agenda, please respond in the affirmative. George Pucci, Town Council.
Yes, good afternoon.
Okay, good afternoon. Introduction to remote meeting. This open meeting of the Town of Nantucket Zoning Board of Appeals is being conducted remotely pursuant to Chapter 2 of the Acts of 2023. Ensuring public access does not ensure public participation unless such participation is required by law. This meeting will feature public comment. For this meeting, the Town of Nantucket Zoning Board of Appeals is convening in by video conference via Zoom app as posted on the town's website, identifying how the public may join. Please note this meeting is being recorded. All attendees are participating by video conference. Be aware other attendees and viewers may be able to see you. Do not screen share your computer. Anything you broadcast may be captured by the recording. Meeting materials. All supporting materials provided to the ZBA members are available on the town's website unless otherwise noted. The public is encouraged to follow along using the posted agenda unless I or the acting chair note otherwise. Meeting business ground rules. Before we get to the agenda, permit me to cover some ground rules for effective and clear conduct of our business and to ensure accurate meeting minutes. I or the acting chair will introduce each speaker on the agenda. After they conclude their remarks, I will ask each member, inviting each by name to provide any comment, question, or motions. Please hold until your name is called. Further, please mute your phone or computer when not speaking. Please speak clearly to help generate accurate minutes. For any response, please wait until the chair yields the floor to you and state your name before speaking. If members wish to engage in a conversation with other members, please do so through the chair, taking care to identify yourself. After the members have spoken, I will afford public comment to those members of the public that have joined the Zoom meeting as attendees. Members of the public who wish to speak must state their names, be acknowledged by, and speak through the chair. Finally, each vote taken in this meeting will be conducted by roll call vote. Okay, so that covers that. At this point, I would like to call to order the special meeting of the Town of Nantucket Zoning Board of Appeals, this 19th day of April 2023. I would ask for a motion to approve the agenda as posted.
So moved.
Madam Chair,
Oops.
second,
I'm sorry, hold on. Who was saying Madam Chair?
me, Billy.
Oh, hey,
We, the executive session portion was it wasn't posted correctly, so we're not gonna be reviewing that portion.
yeah, I was going to address that
Okay.
at section 4. Then that's okay. Thank you for bringing it up. Okay, so we're still going to approve the agenda as posted. So I forget who made that motion.
I did.
John makes the motion and Elisa seconds. Okay. Again, I will do roll call vote on that. So what? Okay. Elisa,
aye,
Michael. Is he not here? Okay.
Madam Chair.
Madam
sorry,
Chair,
Excuse me, Michael's coming on right now. He had selected the wrong link, so I'm getting him
Okay.
on.
Okay, no big deal. We'll skip
Ma-
it.
Madam
Yep.
Chair, just a point of order here. So
Sure.
it was the executive session was not posted, is that right?
No, the executive, we have an executive session on the agenda under item 4, but the matter in that executive session was addressed at the meeting, the regularly scheduled meeting on April 13th. So we don't need to address it today. It's already been handled.
Okay, the reason why I think there's a lot of things that would be discussed in it or need to be discussed in an executive session.
Mhm.
And what are we voting on here?
We're not voting.
I-
We're not voting on anything. We're getting an update from town council, but when we get the update from town council, at the conclusion of that, if you want to suggest an executive session to follow up that we can have a discussion on this, the update, that we can do that.
What's the effect of not approving the agenda? I just don't think we should have this meeting right now. I think we should hold off and just make it an executive session. At another date.
I don't know that I've never had an agenda not be approved. And I think that because staff can correct me or direct me here, but are we required to have, what happens if we don't approve the agenda, but because it's been noticed, and don't we have an obligation to have some semblance of a meeting?
Yes, I would say you need to have some form of conversation about this agenda.
Okay.
Okay. Okay, so we have a motion made and seconded to approve the agenda as posted. So again, Elisa, you said aye.
I did,
Okay, John Brescher,
Aye.
Jim Mondani,
Nay?
and myself, aye. Okay, so that's 4-1. So that carries.
Madam Chair, I think Michael O'Mara's on.
Okay,
I'm
great.
not-
yep,
That's okay. We just needed 5, so I think we had 5 that voted. I see Michael. Thank you. Right. 1, 2. Oh, maybe we just had 4. Sorry. 1, 2, 3, 4. Okay, Michael, do you want to vote on approving the agenda or not?
Aye.
Okay. Okay, so that carries 4-1. So at this point, I am going to turn this over to George Pucci, Town Council, to give the board an update on Surfside Crossing. So Mr. Pucci, the floor is yours.
Thank you. Good afternoon, Madam Chair and members of the board. This is George Pucci from KP Law, Nantucket Town Council. Just by way of quick background, you'll recall that the ZBA had previously voted to appeal the Housing Appeals Committee decision, which overruled the board's comprehensive permit decision on the Surfside Crossing development. Subsequent to the ZBA's vote to file an appeal of that, the Select Board, which controls litigation to which the town is a party as executive body, as the executive authority for the town, voted to approve the filing of that lawsuit. And that lawsuit has been pending in the Superior Court. It appeals the Housing Appeals Committee decision overturning the board's comprehensive permit decision. Last Thursday at a executive session to discuss that litigation amongst the Select Board voted to dismiss the litigation. And the reasoning so what they voted was to dismiss the litigation, not to discuss the matter publicly until a statement had been issued explaining that and disclosing that fact to the public, basically the vote. Unfortunately, for constraints of the open meeting law, the zoning board, who is a named party to the litigation, we couldn't notify you as a board, as a quorum, unless it was in the context of a duly noted public meeting. So unfortunately, there was no ability to confer with the zoning board prior to that vote or the issuance of the statement explaining the Select Board's vote. So staff for Planning and Land Use Services conferred with you, Madam Chair, and I believe this was the first meeting as a quorum that the board would be able to notice to be updated on the Select Board's decision to dismiss the lawsuit against, which is pending actually against both the Housing Appeals Committee and Surfside Crossing. Due to the attorney-client privilege, I'm not at liberty to discuss any type of advice that I've given to the board or the substance of any discussions that I had with the board in executive session. So I would refer any type of questions that you may have for the reasoning behind the board's decision to the public statement that the board had issued, I believe, yesterday. Again, you are a named party to the litigation, so we wanted to make sure that the board was at least advised before we went ahead and dismissed the lawsuit pursuant to the Select Board's vote. So I'm here. I'm available, obviously, to answer any questions that you have, but subject to that reservation that I, really can't get into discussions, the substance of communications that I had with the Select Board in connection with their vote to dismiss the lawsuit. And again, I would defer to that public statement, which was meant to provide both you and the public of the reasoning for the board's decision at this time.
Did board members, I can see all of you. Would you just raise your hand and if you received a copy of that public statement? Nobody. Okay. Can you read the public statement, George, or would the staff read it into the record? Because we did not get that.
Yeah, or a staff, I don't have it in front of me. I wasn't really in connection involved with the issuance of that. I know Tucker is here today. Maybe he has it available. Either Tucker or staff. I don't know if anyone has it available to read to you.
Has anyone, okay. Has anyone on the board seen the public statement that was issued by the town?
No, is that Jason Graziadei? Is he? the public? Is that that's who I heard it from.
I
Oh,
saw postings on the current, but no, I don't have any
Well,
from the town.
Okay.
It was paraphrased on the current. And I did see it.
Right, but that's the current, not the town. So
This
Nikki,
is tongue in cheek, but yeah, that's how we get our information from the town.
right. So Nikki or Billy, can one of you read us the statement that the town made dismissing the litigation, because no one on the board has that or has seen it?
And I think Erica has her hand up, Susan, and
That'd be
she
great.
might have it.
Okay. Hi, Erica.
Hi, I do have it if you want me to read it,
Yes,
unless
please.
one of your staff members is good.
Nope, that's fine. You can read it.
All right, issued by Town of Nantucket Select Board and Surfside Crossing LLC. Embargo date Tuesday, April 18th, 2023, 2 p.m. Joint statement. While much work has been done in recent years, the Select Board, on behalf of the Town of Nantucket and the developers of Surfside Crossing, recognize the acute shortage of year-round housing on the island, particularly ownership opportunities. The situation has only worsened in recent years and is now challenged by greatly increased construction costs and an elevated interest rate environment. Meanwhile, thinking by the Select Board and the developers, and perhaps the community overall, has collectively evolved during this time to a point where the desire is to jointly embrace opportunities to assure that a significant majority of the units in the Surfside Crossing development are reserved for year-rounders. Accordingly, the Select Board, on behalf of the town and the developers, have agreed on a set of principles that allow them to shift away from the appeal of the Housing Appeals Committee, HAC, decision and move forward in good faith collaboratively. The Select Board and the developers acknowledge that there are two separate appeals outside of the town's control. The Select Board does not support these other appeals. These principles are: 1, the Select Board and the developers agree that the best version of the project allows for 75% of the project to directly serve year-round housing needs. 2, to that end, all parties are committed to working together to achieve the 75% year-round objective through whatever viable long-term deed restrictions at a variety of income levels, e.g. AMIs from 100 to 240%, above and beyond the 40B requirements that 25% of the project be restricted at 80% AMI or less, and up to and including simply a year-round restriction without any income element. In all cases, if law or practicality does not permit a permanent restriction, the minimum restriction length would be 30 years, potentially with an option to renew. Permanent restrictions are desirable. 4, for the units that are to be year-round, e.g. the 75%, there would be a requirement that they are owned either by year-rounders or by local businesses or local nonprofits for the exclusive use of their local employees. 5, it is important to ensure equal, if not greater, opportunity for individual ownership alongside any local businesses and/or nonprofit ownership. 6, all parties recognize that this is a private project and that commitments from other parties, e.g. local businesses, nonprofits, philanthropists, town/affordable housing trust fund, are needed in a timely manner prior to a planned summer construction start in order to define the potential restrictions and to have them vetted and ready for implementation by the time the developer begins any pre-sales. 7, all parties recognize that the municipality and its affiliates, such as the Affordable Housing Trust Fund, need to be provided adequate time to implement restriction programs, e.g. 6 months. 8, all parties acknowledge it is important not to impede the project's forward progress and understand that work with interested stakeholders to affect year-round restrictions is commencing now. 9, all parties recognize that under the 40B law, the financial structure of the development is designed to enable a return of up to 20% of developmental costs, and that the economic feasibility of the project requires preserving a realistic projection of earning this profit. Therefore, in order to earn the target profit, restrictions that reduce the value of the unrestricted market rate units will need to be offset with public or philanthropic grants or subsidies. Generally, the size of the subsidy or buy down needed for restrictions on a unit by unit basis will be based on the difference between the unrestricted market price of a unit had the majority of these market rate units not been restricted, and the price of a year-round buyer is willing to pay with the restriction in place. In summary, the select board in town of Nantucket are actively engaged with the developers of Surfside Crossing and others with an aim of reserving up to 75% of the homes in the development for year-round Nantucket residents. While there are details to work out, and importantly, other potential collaborators to involve, the select board on behalf of the town has, at the request of the developers, elected at its April 13th, 2023 executive session to drop the appeal of the HAC's issuance of the comprehensive permit as part of beginning this collaborative process. The select board has determined that at this point, given the urgent need for affordable and attainable housing, the interests of the island are best served by all parties working collaboratively on this set of shared principles for assuring that this development serves year-rounders to a very great extent. If these project goals are achieved and 75% of the project can serve the year-round community over the long haul, this could be a model for how 40B could work in other seasonal communities. I will email this to Nikki and Billy, and that way they can forward it on to the board so you have a hard copy.
Thank you, Erica. George, do you have anything to add to that?
No, thank you.
Okay. Does anyone on the board have a question that they would like to ask or comment about anything for George specifically at this time?
Yes, Madam Chair, if by making a decision to withdraw the litigation, George, do you have an agreement on, I hear up to 75%. I hear a lot of loosey-goosey language in that. And do we have some hard, fast agreement to withdraw litigation in return for these milestones?
No, there's no written agreement. There's no type of settlement agreement or anything like that in connection with the litigation. All the vote is to instruct me to dismiss the lawsuit after the issuance of that public statement. And, we wanted to make sure that the board was advised of that in advance.
Okay.
Wait,
So
I just want to,
basically, it's on the good faith of the developer to follow through.
There's nothing beyond what Erica just read. Correct. There's nothing signed, no settlement agreement.
And would you typically just withdraw litigation with no agreement with that other party?
Yeah, that's tough to answer in the hypothetical. I can really only tell you what happened here. And,
Okay.
and I don't mean to be cavalier or flippant to any of the board members. It's just, there are certain constraints. There's attorney-client privilege. There's, again, the difficulty of conveying to a named party in litigation in anything other than the context of this noticed public meeting. So I don't mean to be dismissive of any questions or comments that you might have, but I'm just kind of constrained by the circumstances existing on this particular matter.
Yeah, no, and that's why I objected to the agenda, because I think an executive session would be, Madam Chair, the right thing, which is what we do with all litigation in which we're a party. Any strategy is discussed in an executive session, and for some reason we were usurped on this one. And it's frustrating to have to go through all of what we went through and then our decision is usurped by the housing authority. And then our decision-making authority is usurped by the select board. So I'm trying to understand what our role. It's very frustrating, and I didn't see a lot of good faith in when we went through this original 40B by pulling the rug out on us at the last minute and having us make a decision. Some of the board members don't remember that or weren't here. And I don't really see a good faith follow through on this. in the name of affordable housing. We've given up everything in the name of affordable housing. And I think what the town should have done is rezone that property in the name of affordable housing instead of pulling this away from the zoning board and yet keeping it within 40B so that we're going to have to still monitor all this. And it just doesn't seem right at all. And no other stakeholders are involved in this decision. And it's really frustrating. And I don't understand why the board was not involved in this. So we are still to continue to administer this 40B the way the select board wants us to. And what is that's not the purpose of the 40B. Unless we want.
That last, I'm sorry, Jim, but I took that one, I took that last comment as a question, and that is something that I can answer. And I did not mean to interrupt you. The Zoom format is difficult, but yes, aside from what the board is trying to negotiate with the developer, that's 100% correct. What you just said is, so now in terms of the board's jurisdiction, regardless of the dismissal of the lawsuit, you're still the board of jurisdiction over this. So what you're going to have to do is, you're going to have to monitor compliance with the final plans as amended by the Housing Appeals Committee decision in terms of what's before you jurisdictionally. And that's not going to be an easy exercise because you have to kind of go between those two decisions to see what's been struck and what not, and how to implement that. So, right. We're certainly available on approval from the town manager to continue to assist the ZBA on those issues. So I just want to be clear on that there are certain issues that are wholly within your jurisdiction, which will continue.
I'm Chair, I thank you, George. We've spent a lot of time on this, and I feel like this is very frustrating to hear this now. And what I would ask is you and to get a statement from the select board of how we should conduct these meetings. Do we just scrap everything in the name of affordable housing, meaning size, shape, density, sewer, emergency access, all those things that the select board was in agreement with? We've scrapped this for affordable housing. And that's why I think it should just be rezoned for this by the select board, by the town. And that way we don't have to go through this. And I guess what I'm getting at in this long talk is, I'd like to explore, and George, this is more for you. Can we pursue our own separate counsel on this?
George, do you want to answer that? And I also wanted to, George, I also wanted to ask if some of these questions and concerns that Jim has and other board members may have, as Jim mentioned earlier, is it appropriate to have an executive session to talk about these things?
Not really. It depends on what your subject is, because if the lawsuit is dismissed, there is no reason to be an executive session over it. In terms of counsel, your town charter has specific provisions on that. One of your town boards, such as you, have the right to actually vote your own counsel, but only in a specific instance where you're a party to litigation where the town is on the other side of the V sign, basically town versus zoning board, select board versus zoning board, something like that. So just in terms of just a preliminary opinion to that, just based on the town charter, it's only in that specific instance where you have the right to insist on your own counsel.
Okay, I see John Brescher has his hand up.
Thank you, Madam Chair. Through you, George, who was representing the zoning board in this appeal?
I am representing the zoning board in the appeal. I filed a
So-
complaint on behalf of the zoning board.
So how can you say that the town has attorney-client privilege? Aren't you serving us?
The discussions this is an open meeting. My discussions with the select board in executive session were subject to the attorney-client privilege, in addition to being an executive session. If I were to meet with your zoning board in executive session, my communications with you would also be protected by the attorney-client privilege, but we're in an open meeting that is being attended by third parties who are not part of the attorney-client privilege. So obviously, this would not be privileged, but it doesn't remove the privilege for the communications last Thursday with the select board.
Okay, frankly, Madam Chair, I'm not really satisfied by that response, but I think I'm going to echo Jim's comment that we will need, I think it behooves us to have our own executive session on this, because this is, yeah, I think I think there are a lot of topics that we need to get into that are subject to this litigation, or were subject to the litigation, which evidently can be dismissed without our knowledge or approval or assent, even though we're a named party represented by the same council.
Yeah, Elisa, I see your hand. I just want to say to George. So George, I understand what you're saying, that we can't discuss certain things because we're not in executive session. But when we're asking, I just asked you if we could have an executive session. You said there's no reason to have an executive session because the litigation, it would be the topic of the litigation is dismissed. Some of the things we would want to talk about have to do with this non-settlement agreement that's been put out to the public, not to us, not provided to us except on social media, which I don't rely on social media for my news. I would have thought that the town would have shared the public statement. And in fact, I requested that be shared with me and the board from several members of our town government who are stakeholders and participants in this, and we were not provided anything. So the board came to this meeting not prepared at all and not knowing what was agreed to, but put that aside. So again, we are in an open meeting. The board members who are going to be required to administer this decision, your hearing, are interested in an executive session to get more information, and as our counsel, speak with our counsel about what happened. You're saying you can't talk to us you can't explain the select board vote because you're not at liberty to discuss the advice that you gave when you are our
let's be
attorney as
clear.
well.
The select board did not dismiss the lawsuit on my advice. I'm advising you that I had communications with the select board in executive session
Right,
connected
sorry.
to the lawsuit that are protected by the attorney-client privilege. The select board voted to dismiss the appeal. The select board is the executive authority with jurisdiction over what litigation the town is going to be involved with or not involved with, and they made that vote. And they wanted to advise the zoning board of appeals ASAP about that vote. So there's not, and in my opinion, you're free to accept or reject my opinion, but once the lawsuit is dismissed, in my opinion, you would not have valid grounds to go into executive session for the purpose of discussing litigation because it's dismissed. There's nothing, I've never seen a board be able to discuss something in executive session after the reason for the executive session has passed. And I understand totally the frustration of the timing of it, but I'm just here to tell you what the board's vote was, how it went down. I assumed you did have the public statement before today's meeting. I wasn't instructed to get that to you beforehand, so I was not monitoring that. But so it is what it is. I'm not sure what is unclear or frustrating about my answers to these questions.
Okay. I think it's just, I I don't think your answers are frustrating. It seems like it would have been better to have this be an executive session. So Elisa, you had your hand up. Did you have a question or comment for George?
Sort of, well, not necessarily for George, but I guess if we go to executive session, what I have to say will be talked about more. So should we, I don't know if everybody, I'm not going to make a motion, but at this point, my points were going to be who has the power and the authority to enforce and monitor or police all of these things that were said in the statement that Erica just read to us. I want to get a better handle because I was not on the Zoning Board of Appeals when this whole 40B was originally presented. So I'm catching up, but now my vote counts and I want to make sure, you know, more so than just deed restrictions, I want to have answers on, again, how this will be enforced, monitored by who. I have a lot of questions before I vote to dismiss the lawsuit by the town.
So the lawsuit has already been voted on to be dismissed by the select board. We don't have a say in that. That's already been
Okay.
done.
What are you voting on?
I don't know if we will be, I don't know what was discussed in executive session for the select board. So I don't know who will be in the negotiations to work out those things that are on that public statement that Erica Mooney read. But we, as the Zoning Board of Appeals, are the enforcement arm for the 40B comp permit. And so whatever, so we would be the enforcement for what's in the comp permit.
So
George,
we're not voting on anything today. We're just having a meeting.
no,
Gotcha.
we're just getting an update. And so this is the update, that the litigation has been voted on to be dismissed and will be dismissed. It seems soon, too soon for us to schedule a executive session. And then there will be a good faith effort by the developer to work with the town and other stakeholders that were named in the statement to work through those, I think it was 9, maybe more, 9 points. Again, I don't have it in front of me and I haven't seen it. So hold on, Jim has his hand up. John, did you have your hand up, Brescher?
I did, but I can hold off on my comment for now because it's really more frustration than anything substantive.
Okay, so I'm going to go to Jim, and then if the board doesn't have anything else for George, as this is a open meeting, we will take public comment. I don't see on my screen any hands raised, but maybe Billy and Nikki do. So we'll go to Jim. I'll see if anyone has anything else to add. And George, I just want to say the frustration isn't with you and your answers. Your answers are perfectly acceptable. You're telling us what's what and what the situation is. I think it's just frustration with the situation and sort of being the last to know after a lot of effort and time went into this decision.
No, I totally understand. I'm not, I hope I'm not coming off again. I'm not trying to be cavalier or dismissive with you. I'm limited in the, my ability to discuss this fully with you in terms of the, pros and cons or anything like that, or, the issues about the litigation and all of that. So, I respect your board greatly. Obviously, I worked with you for many years. So I don't mean it to be an unpleasant presentation, but the timing is just what it is. One thing I do want to say, I wasn't involved in noticing your meeting. I think probably whoever was doing that is erring on the side of keeping things open and public, at this point was probably the desire. And unfortunately that results in, you not being able to have an executive session to, you know, talk about things subject to the attorney-client privilege fully and freely. So it's difficult, but I think probably the philosophy behind that was so that, you know, after that public statement was issued, that the public not perceive that, you know, things were happening outside of their ability to monitor what was going on, probably err on the side of having things public once that vote was made public. So, but again, these aren't decisions that I made, but it's just something that, you know, I would think would make sense to try to keep an open public dialogue going once that vote was announced.
Mhm. Okay. Okay, sorry, Jim, you had one more thing to say.
Yeah, just I echo Susan's remarks, George. You did a great job representing the board during the sessions. Just procedurally, whatever is agreed on these additional provisions on affordability, does that then get sent to HAC? Is that a change to the comprehensive permit that was approved by?
Yeah, that's a really good question. That would be a way of doing it, would be a modification to the Housing Appeals Committee decision. That I've been involved in that type of process before, that the parties submit something jointly and they amend those affordability provisions and conditions, and then the HAC approves that, and that becomes conditions in the permit.
Okay, so anything that was mentioned in the press release would be an amendment in your view, you think?
Yes, correct. Well, there's a multitude of ways of achieving it in writing, like you're saying, enforceable conditions that are recorded. That would be one way of doing that. You know, so a joint submission back to the HAC, which are, you know, pretty much always approved, because, you know, the goal is to get the parties to, you know, resolve something along those lines. So that would be one way of doing that. Having the types of conditions that were in the statement read by Erica enforceable, that would be one means of doing so.
Thank you.
Okay. I don't see any hands up for board members. Oh, Michael has a comment.
I would anticipate, having gone through litigation that ended up in the selectman's lap for many times, that once the selectman and the applicant get a list of proposed conditions, that it would get passed under the nose of the zoning board before it's approved. And I've also seen this type of situation that ended up in the selectman's hands be helped by a person from the zoning department or the board.
Well, let's hope that happens again this time. And I think that the members of the board that sat on this comp permit and the members who are new, who didn't sit on it, would be willing and eager to be part of the process, since we will end up being the enforcement agency for most of the decision, if not all of the conditions on this wish list. So I'm going to open it up to any member of the public participating as an attendee, if anyone has anything to add at this time. I don't see any hands up on my screen. Nikki or Billy, do you guys? Oh, I see.
Yes, I have a couple of hands up, Madam Chair.
Okay, I think Ann Atherton was the first one to put her hand up.
Thank you, Madam Chair. Can you hear me?
Yep.
I have a procedural question also, trying to understand the steps here. And according to Attorney Pucci, the select board voted to dismiss the suit. Has the suit officially been dismissed with the court?
George, do you want to answer that for Mrs. Atherton?
Yes, I'm happy to. And I want to note, Susan, I'll be silent unless and until you ask me to answer something. I do everything
Of
through
course.
you as the chair. So yes, I'm happy to answer that. No, the answer is no.
Okay, thank
There's
you.
been nothing formal filed in court as of yet.
Madam Chair, I have a follow-up, please.
Sure.
If that indeed is the case, is it an option for the Zoning Board of Appeals, for your board, to request a delay in the formal processing of that?
I don't believe so, because the Board of Selectmen acts as the executive or has the executive function for litigation with the town. And George, if you can say that in a more succinct way, or if I've said it incorrectly, please feel free to correct me.
No, I have nothing to correct you on. The board is free to make any request it wants, though. I mean, this is you're meeting as a quorum, you know, in a duly noticed public meeting. You're free to make any request that you want to the select board. I'm happy to convey that, or hopefully they're monitoring. I think Erica is attending the meeting, and that would certainly get conveyed to the select board. So I'm not telling you in any way, shape, or form, you're not fully free to make any requests that you want of the select board. I'm just explaining kind of the process about who controls the litigation, but you're free to make any requests you want.
Okay, thank you for clarifying. Is that the end of your public comment, Ms. Atherton? And I can move on to Ms. Stockman.
Madam Chair, I just have one other question. I'm not sure if any members of the board can answer it, or if Attorney Pucci can answer it, but who negotiated the set of principles with the developers on behalf of the town?
I don't know the answer to that, but I don't know. I don't know. George, do you know the answer to that? Or Erica?
No.
Do you know?
No. I do know that the statement that was issued with those bullet points was, you know, something that the board talked about issuing. That was how they wanted to announce the vote to dismiss the lawsuit. But I don't know the universe of individuals who may or may not have been involved in negotiating the bullet points that are set forth in the statement. I was not present for any of it.
Erica, do you have any input on that?
I don't either.
Okay.
No.
Okay. Elisa, you have a question?
Hi, Elisa Allen. Sorry for my ignorance, but what is the point of this meeting right now if we can't vote on anything and we were just informed of the statement that what has been agreed upon between the two parties? We've now been on this call for I don't know how long, but what is the point of this meeting? Being held publicly, number one, being held only moments after we heard what's been negotiated, and we're not here to vote on anything. Why are we meeting?
We were only meeting to allow or to get updated on the status from George and from town council and ask any questions that we may have. And because we are not voting on anything other than when we vote to adjourn. And because it was noticed as an open meeting, not executive session, and there was an executive session item on there that we don't have to address, we take public comment. So
Okay.
The board is, I mean, the board, we don't, there really isn't any point to this meeting other than us asking questions and members of the public, I guess, asking, I don't have any information.
Mhm.
So the only questions that.
But we have no influence on anything anyway.
No, right, I know. So for public
Okay.
comment, we can have people give their comment. I can't really answer any questions because again, I don't know,
Yeah.
none of us had any information about it until.
Yeah, I don't mean to put you on the spot. It's really
fine, it's fine.
my lack of knowledge.
Yeah,
of
I
how
mean,
this
I
works.
don't think there's I don't think we need to go on and on because
Yeah.
we don't have,
Okay.
there's nothing to really say. So, and I think so I guess I should say this, for members of the public who are going to speak, I see a few hands up and you will get a turn. However, the zoning board does not have any information other than what was read into the record by Erica and what was posted on social media about the decision to withdraw from litigation. So please limit your questions to,
Thank
I
you.
don't know, something we can answer. Ms. Atherton, are you done with your
Yeah.
public comment? Okay. So I'm
Yes,
gonna
I am, Madam Chair. Thank you very much.
Okay, you're welcome. I'm going to move on to Ms. Stockman had her hand up, and then I have two Perrys. I have Megan and Michelle, and I think Michelle is first and then Megan. So Ms. Stockman, if you could go with your public comment, please.
Yes, absolutely. Thank you for listening. I just want to clarify that I understand what I heard in that town council was not there when this list of hopes and dreams or the suggestions for going forward with Surfside Crossing, that there was no legal kind of counsel in that. And so that's the question for Mr. Pucci, if he knows. Was there any kind of legal representation there advising on such an important issue? And then my comment would be that I'm not clear about how the ZBA could possibly be responsible for administering conditions when there actually are no conditions. There's nothing that's binding at this point. Thank you.
Okay, so I believe Attorney Pucci was present at the executive session.
Yes, I mean, I can give a quick answer to that. I was at
Okay.
the executive session. I had communications with the select board was held remotely by executive session. There are two privileges. One's executive session, the ability to go into that, but there's also the attorney-client privilege. So even if the reason for an executive session is, the lawsuit that's the subject of that ends up getting dismissed, communications during those executive sessions are still subject to the attorney-client privilege unless and until the client waives that privilege. So there's sort of a privilege within the privilege. So the actual communications are also protected. And those privileged communications implicate other policy concerns that, a client has to be able to freely consult the good, bad, and the ugly with counsel. And that's why that's subject to a separate privilege in addition to the executive session privilege. Quick answer to that question about my presence or who participated. I attended the executive session last Thursday, but there was no one from Surfside Crossing at an executive session, because they're the party on the other side of the litigation. So they had no ability to attend that meeting. None of those bullet points that are reflected in the public statement were negotiated at the executive session. And I am happy to, not happy or not, but I am free to answer the factual fact that I was not present at any negotiations that may have taken place between town representatives and Surfside Crossing. So, hopefully, that I'm being clear about that, about who attended what, when, and when things were negotiated. I wasn't part of those discussions with Surfside. And then the other one, another one is actually an important question and distinction. There are issues concerning implementation of the final plans of Surfside and conformance with the ZBA decision as modified by the HAC. That's in no way, shape, or form affected by the select board's vote to dismiss the litigation. That's something that the zoning board is going to have to deal with in a, consulting with the building commissioner and department heads in terms of compliance and ability to construct in accordance with those final plans, like on sewer issues or all of that. So you'll rely on your department heads as you typically do in terms of implementing that decision. You'll maintain jurisdiction over that. In terms of the bullet points that are reflected in the public statement, that you're not directly involved in, continuing negotiations with Surfside to implement those conditions. Again, you're certainly free to request to the select board to be part of that process through, a representative of the board to take part in that. And then in the event that any of those conditions are actually achieved and the town wants to have them enforced, that will probably come back before you in terms of a proposed modification that I talked about in response to Jim's question earlier. So in terms of, you just have to, you can't mix all of these issues together. There are certain buckets of each thing and where we stand right now. So hopefully that clarifies it a little bit.
Okay, thank you. That was quite clear to me. Does that answer your question, Ms. Stockman?
Well, it makes me kind of come to a follow-up. Attorney Pucci, were you just saying that it's possible that during this process, the issues are going to come up before the ZBA for approval again? Is that what I heard you say? Thank you.
They could, yes, in the form of proposed modifications to the permit that would go back to HAC. So
Thank
they
you.
could.
Okay. Michelle Perry, I see your hand is up.
Good evening. Actually, this is Bruce Perry.
Oh, sorry, Bruce, it says Michelle.
It does say Michelle. She started. I just got home from work and
Okay,
grabbed the mouse away from her so I could.
okay, go ahead.
So I got a couple points. I don't know if those of you do or do not know me. I was involved in the Nantucket meetings for a couple decades, and I think the point that you're at a public meeting duly posted that the ZBA can vote on whatever it wants to. It's not precluded from voting. And one of the votes that I would recommend that you guys take is that you would object to this alleged agreement with between the selectmen and the developers to drop the litigation, and that you still support the litigation, and that is well within your purview to do if you so choose. So the other question was, the board, I'm sorry, I'm looking at my notes I scribbled as I was coming in the door. Where's the other one? Oh, the executive authority comment that Mr. Pucci made. So is he basically saying that the selectmen can overrule any decision by another board if they disagree with it, even though the board still wants to support its decision? I guess that's my question to him.
George, do you want to address that question?
Yes, no, the select board doesn't have the ability to overrule a decision within the board's jurisdiction, but the decision on whether to proceed with litigation that the town is funding is within the exclusive jurisdiction of the select board. So they control litigation. If they decide that they do not want to continue to support litigation, they do have the ability to override the board. It again, except in the specific instance where the town board is being sued by the town, like for example, town of Nantucket buying through the Board of Selectmen versus the Zoning Board of Appeals, in which case the Zoning Board of Appeals would have the ability to vote its own counsel to represent it in that litigation.
Okay, thank you.
I follow up a little bit on that.
Sure.
So basically the board of selectmen, or the select board, sorry, by cutting off the funding to town council to defend the ZBA's decision is effectively cutting off the ZBA's ability to pursue the litigation, even though it wants to. So the other thought that the ZBA should consider is whether or not it should immediately get independent counsel to file a motion with the court to object to the dismissal. That is also within your purview to do, and whether you want to do it in open session or executive session, that is something you should do if you feel strongly enough that you should support the previous board's decision. It's happened in the past and it'll happen again. So I'll just leave it at that for now. And my other questions were answered by previous people. So thank you.
Okay, thank you, Bruce. Megan Perry and then Emily Molden. So Megan, you have the floor.
Thank you, Madam Chair. I just wanted to say that I, as someone who attended almost every one of the ZBA meetings regarding this with many of you, I am extremely sympathetic to the position that you're in. And I'm sorry it's going down this way. Along those lines, I've sent a couple emails into the ZBA with some questions, and I wasn't sure if the board had received them and was able to answer any of those questions. And some of those were, my understanding is the developer has already made some violations to the conditions. Is that something that this board is able to look into and enforce? So that was my first question.
Okay.
And then my second question would be I'm sorry, what?
I was just going to try to answer the first one.
If the select board is now, did you want me to wait? I'm sorry.
No, that's okay. Let's address the first question first. I saw an email that came in to Billy Saad today. I don't have the answers to those questions. If there are, and I don't have knowledge at this point of any violations, but if you think that there are, if you haven't already, I would send those to staff so they can be looked into and looked at.
So that in the email thread that I sent along, it's in there, they're listed in there.
Okay. So then I would say that staff is probably looking into it or working on it or will be working on it. And you had a second question?
Sure. And maybe this is a question for Attorney Pucci. I'm not really sure.
Megan, we may have lost you.
If the select board is now partnering with Surfside Crossing, is there then a
Can you
telling the
say that
ZBA what they can
again?
and cannot? Is that any better?
That now it's better. Can you just say that again? We lost you. You
Sure.
said
If the select board is essentially partnering with Surfside Crossing, is it then a conflict of interest for them to be essentially dictating what the ZBA can and can't do with regards to wanting to potentially pursue this suit?
I would hesitate to use the word partnering. I think they're entering into, as they said in the public statement, good faith negotiations, which is their right to do. I don't think that they would be forcing us as a board to do anything. The Zoning Board of Appeals is the enforcement arm for a comp permit. So if there are any of the conditions on that public statement or press release do come into existence, and there's an enforcement arm to it, and it comes back to us to be codified as a amendment to the comp permit as approved by HAC, then we would be the enforcement arm of that. But there are other ways, as Attorney Pucci said, there are other ways as well for the select board or the stakeholders who do the negotiation, of which the ZBA may be one of them. We don't know. There may be other ways for those to be enforced, that those specific things that are not currently in the comp permit. George, just before I hop over to you, Jim, George, do you have anything to add to my response there? Is that a complete response or?
Yes, no, I have nothing to add.
Okay. Jim, did you have something to say about Megan's question?
Yeah, until we get more than a press release to go by, they are in a partnership. From what it sounds like in the press release, by funding down payments and by purchasing things on behalf of the town, that's a partnership. And as again, we're the board, I guess, that oversees, enforces, and implements these things. And until this meeting, the only information we had was from Jason Graziadei. And that's incredible that we have nothing to enforce or even know. I mean, there are probably people here on this meeting that have negotiated with them that are not, that can't give us any information about what the deal is. How are we going to implement this based on and I know things will be negotiated more, but how are we going to implement things on a press release after spending a year and a half going through this? And since I'm still on here, George, you'll recall that we discussed specifically some of these things in our review about restricting things to locals. And I don't even know if this can be done. And in your view, do you think it can be done legally?
Right,
George?
yes, right. Anything that's in those bullet points, we would have to render opinions on it and provide a form by which those could be accomplished. And yes, I do recall that in one of the winters of these ongoing discussions, there were a lot of discussions. I should note though, and I totally get your concern from your perspective. Right now, there's nothing for you to implement. The bullet points on that public statement are just that. They're bullet points in a public statement about trying to explain to the public what the select board's current decision making is on this in terms of its position with regard to the Surfside Crossing project and with regard to the litigation. But unless and until those conditions are actually the issues that are set forth in the bullet points actually confirmed, between the town and the developer, there's nothing for anybody to implement. If they are achieved, then they would be put in the format, approved by council of how those would be enforceable. But unless and until that happens, there's nothing to implement on that statement right now. The things for you in your immediate jurisdiction are like the type of thing that Ms. Perry just talked about. If there are certain flaws in the final plans that have been presented to you, those are still fully within your jurisdiction to work out or to enforce against the developer. So those are two separate issues. But right now, those bullet points that are set forth in the statement, again, are just, policy statements about what the town is trying to achieve with the developer.
And let me remind you that we went down this road. We had bullet points, and without any agreement similar to this, and the rug was pulled out from us. So I just want to remind everyone of that. So there's no guarantee here. That's my point. There's no agreement.
Correct. It's not an agreement for judgment or anything that, right? Absolutely.
And was there any other negotiations besides the affordable housing? Because there was a list of things. Or did we just give up everything? Every other concern.
Yeah, again, I wouldn't really be able to get into that. Again, I wasn't at those sessions.
Okay.
I have a question. I spent some time looking at the final plans last week. Is there someone on staff, or George, is that as town council, is it your office's job, or who has the responsibility of going through, like you mentioned earlier in the meeting, the plan, the decision that we submitted versus the decision that HAC approved, and the plans that came back to make sure that there aren't any flaws in the final plan submitted? Because we mentioned this at the last meeting, I think, or there was discussion, maybe it was today, about the 90-day, I think it's a 90-day review period, or once the developer submits the plan. Nikki or Billy or George, is there who from the town is tasked with making sure that the plans that were submitted match what HAC approved?
Susan, I can answer that.
Okay.
Leslie did make mention of it at the last meeting that I believe she said we received the final plan set on March 22nd, but I did double check that and it was March 21st.
Mm-hmm.
She did distribute those to applicable town staff for review, and also the engineer that the ZBA chose during the process for his final review. So
Okay.
There is an engineer involved that has been forwarded the plans. I don't know that we've gotten a response.
Okay, thank you.
And I should specify, I appreciate that response. I should specify, I have not been involved in that process as of yet. Obviously I'm always available to assist as needed, but I am not conducting any ongoing review of those plans. And again, I'm available to assist if needed. I'm available to assist if you want to sift through the HAC decision versus your decision to see which of your conditions remain and which have been modified or stricken in their entirety. That 90-day deadline was actually, I think, was a condition in your permit. I remember putting it in it. I seem to recall, and again, I haven't been doing an ongoing review of the final plans, but I thought that the HAC modified that 90-day period. But I'm assuming that the developer is in good faith with you that they're abiding by that 90-day review period, because I think the HAC might have used a different word for that, like expeditious review or something like that. So, it would be helpful if you clarified that with the developer about what exactly, their expectation is in terms of your deadline for confirming compliance. And again, you want that whole process that I'm sorry, I don't know how to pronounce his last name. I haven't been with you before. Billy SAD or a SAID, you want to make sure that you have time for the engineer to weigh into you, the sewer director, all of that. That's a pretty complex prospect, and it's a time-consuming effort to go through to compare the extent to which your conditions have been stricken, so that you know what it is that you're seeking to comply. Conditions might have changed too, in terms of current on-the-ground conditions, that certain things ordered by the HAC may no longer apply, depending on what's gone on from the town's infrastructure efforts, or whatever the on-the-ground situation is now versus the time that decision was issued. So, you just want to make sure that it's a great question to say, who is looking at this. You just want to make sure that review is fully underway and that you have the ability to complete your review.
Okay, thank you. We will, I will follow up on that and making sure that we know what the timeline is and are hopefully able to complete the review as thoroughly as suggested. Megan, I know we were still in the middle of your, you had your 2 questions. Do you have anything else to add, Megan? Okay.
Wait, can you hear me any better now?
Yes.
Yeah, so actually the 90-day topic was one of my many questions that I sent in. What is the actual official date that the 90 days is up? Because I've asked a couple times and I still don't get an answer. I know it's 90 days from the 21st now. What's the actual date?
So we don't know, because what George Pucci just said was we need to double check on that, because it may be something different. So it may not be 90 in the final decision. So we need clarification on that.
But
And
the clock is
if the
ticking.
HAC used a term like expeditious review or something, then you could very reasonably say, well, that's 90 days. But all I'm saying is, I haven't been asked this question before, but all I'm saying is you do just want to make sure that you clarify that, so everybody knows what the inbounds is and the out of bounds, and just make sure that you complete that review within that time period.
Yeah.
So your clock is already ticking, is that correct?
Yes.
Okay, it seems like an awful lot of information that, do you know if it's been distributed to town staff? There's no way of knowing it. Like, that's a lot of information to go over, review, and give an opinion on, and to not know the end date for it.
Right. That's why that's why I asked the question, to see who is reviewing what. And we need to just get some clarification on that.
Okay, thank you.
Yep. Did you have anything else, or?
I think that's it for now. I won't keep going because I've emailed it. And so hopefully I'll get some answers to that. So thank you.
Yep. Ms. Molden.
Thank you, Madam Chair. Emily Molden with the Nantucket Land Council. I just wanted to take a minute and share in some of the expressed frustration and how this has all proceeded and taken place. I especially feel like it's disrespectful to the board who spent so much time on this. The fact that the decision was made to dismiss the litigation without consultation or discussion with the ZBA and without a formal agreement. I really wanted to express some appreciation for the amount of time and effort that you have all put into this over the years. And then I just wanted to sort of follow up and reiterate on Bruce Perry's comments. Actually, I think there is really no reason why, regardless of the result or outcome, the board couldn't vote to request an extension or a delay in the dismissal of the litigation to seek a executive session if that's not possible at this time. And I also don't see a reason why the board couldn't vote to formally object to the dismissal of the litigation under the current circumstances. I think it's really unfortunate, but I do really just want to thank the board for the work and effort that you've put into this to date. So thank you.
Thank you. Okay, so does anyone on the board have any additional comments, questions, suggestions at this time? I see Jim.
It's frustrating on these timeframe things that we have no idea where we are. And I think we should come up with some procedure that anything that's submitted by the developer with a time constraint provides us with notice of some type. Because usually what happens is when that time expires, it's deemed approved.
I think that there was notice. The plans and everything were submitted on March 21st. Billy said that they've been sent to the engineer and circulated to staff members to review, but I do want to follow up on George's point of that he thought maybe the wording was different in the decision, and follow up on different departmental review. So I think that we as a board maybe didn't, like the whole board didn't receive notice, but I did know that things were delivered to Plus. And so that process was going on. And we did, I believe Leslie emailed the entire board, but I could be mistaken, the link to all of the plans and everything that's been that's on the town website. And, you know, you should, in your free time, go and look at them and make sure that it's, because there are some changes. You know, I think it's just Jim, it's you, me, and Lisa, I think, who sat on it, who are still on the board. And of course, anyone else can look at them as well, but you know, definitely spend some time and look at that comp permit that was approved by HAC to see what those conditions now are. Okay.
Just one final thing, since I think we all feel like we're on an island here, that some initiative needs to occur to bring us into the fold of what the mission is. And what the objective should be, whether that's an executive session or some type of joint meeting. I don't know if you agree with that or not.
I think the executive session, George has said, once the lawsuit is dismissed. George, when do you plan on filing that?
I've been instructed to file it following your being informed.
Okay.
It's 5:25 now, so I'm not filing anything tonight. Tomorrow is a business day. I have not prepared a dismissal. I would assume that counsel for the developer is going to forward me a dismissal.
Okay.
That would be signed off on and then filed with the court.
Okay. Okay.
You know, again, it's just, I'm not a guru. It's just my opinion about how executive session works. You know, when the litigation that's the subject of the executive session has been dismissed, in my opinion, you don't have the ability to go into executive session.
Okay. I see, Bruce, is your hand up again?
Yes, it is, if I may.
Yes, and then I'd like to, it's almost 5:30, so I'd like to move on. But
Yes, thank you. I just wanted to reiterate that nothing's been submitted, nothing's been even written by council, as you just said, that the board vote to send a letter or let the town manager know that you voted to object to the dismissal, and ask the board wait to dismiss the case until the agreements are more fully fleshed out. um, you know, as Megan said earlier, they are in violation of their existing permit by starting work. And I submitted an email to the Plus Department delineating the conditions that they're in violation of and haven't heard back. And that was about a week ago. So I think that time needs to be taken, and the ZBA should ask for some time to make sure that one, the developers are in compliance before you give away your only negotiating point. And secondly, that you give more time to review it. Thanks.
Okay, thank you. Michael, did you have your hand up at some point and I missed you?
No, I think I'm good.
Okay,
I think I regarding what Mr. Perry just said, I don't think we've taken any vote to do anything, to my knowledge. If the board wants to do that, I would condone it. What I'm not clear on, because the communication it's not been great here, is whether the conditions that we had on the decision, our decision, have been changed, or some of them maybe even dismissed. So maybe a letter to the selectmen is appropriate.
I agree.
and so you mean a letter that would address the existing conditions on the decision, or a letter to address the bullet points on the press release, or a letter saying that we would like to be involved in the discussion or the fleshing out of those conditions?
Yeah, I think so, since we're going to be the ones responsible for policing it.
I think that's appropriate that we offer our assistance to that effort. Would someone, it sounds like that would need to be a motion to.
I'll make that motion if anyone cares to second it.
I'll second it.
Okay, so Michael's made a motion to draft a letter to the Board of Selectmen in response to the press release offering making them aware that the zoning board would like to be involved in the realization of the conditions or the bullet points.
I think that's sufficient.
Okay.
How about our position on, and I'm not sure what our position is, on the select board's decision?
Someone can make that motion. I think that as it has been described by council, the Board of Selectmen has the exclusive authority to make those decisions. So yes, I would have liked to have been given more notice, or perhaps part of an executive session or something before it was done to have a better understanding. But again, I'm only one person on the board. So if the rest of the board members, that can certainly be.
I just think I agree with you that they have the authority to do that. But I would like to see something more in writing before they formally withdraw their litigation. I don't know if that's possible, George.
Whether they agree to it, I don't know, but
No.
anything is possible for you to make a request.
Oh, right.
I mean, that request can be made. I mean, if you instruct me today to make, tell the town manager that request was made, I'm happy to do that, or you issue a letter, whatever you want. I mean, if that is what the board wants to do.
Jim, do you want to make a motion to that?
Yeah, I'll make that motion. Add that. Do I just amend Michael's motion to add a condition to the withdrawal that they have come up with a,
I'm willing to amend.
Okay, so you want to amend the motion, so we would ask George to draft a letter that says that we want to be a part and we offer our services to help make these conditions. And we request that they delay withdrawing the litigation until we've had a chance to what?
until there's a satisfactory, an agreement that's satisfactory to the parties of what those stipulations are.
Okay. All right, so Jim, sorry, so it was Michael's motion and Jim seconded, was that correct?
And it's been amended twice, I guess.
Okay, so just for procedure, so Michael, would you just make the motion and Jim second again, since we amended it twice?
I will make that motion.
Okay, and Jim, you're seconding. Okay, so I will do a roll call vote.
What is the motion, Susan? I got offered to assist in implementing the conditions set forth in the public statement
And then
and asked not to dismiss the lawsuit until what?
until there's a viable settlement agreement agreed to by all parties, including the zoning board. Is that what we're asking?
Yeah.
I'll second that.
Well, that's already been seconded. That's what we're voting on.
Oh, okay. I thought it was amended again. Sorry.
Okay, so I will go down the list. Elisa Allen,
Aye.
Michael O'Meara,
Aye.
John Brescher,
Aye.
Jim Mondani,
Aye.
and myself, aye. Okay. So,
I'd like to, I don't know if this is a form of a motion, but I would like to explore this additional counsel and would I do it in the form of a motion
I
to
think
explore it, or can we get information on that?
I think that so our counsel is telling us that this is not the appropriate scenario to be able to have independent counsel. So I think if you want to explore it, I don't think it's a motion.
Okay.
I think I don't know. I think that you would, Michael.
But by not voting on this today, I don't think we're foreclosing an opportunity to do that in the future.
Okay, and that's my concern. So
Jim, why don't you could do independent research on that to see where, because we have the opinion from town council that says we're not in the situation to do that, but you could research that to see if you find something else that you think shows that we are in a position to do that, and then we can talk
Yeah,
about
and
it.
to be clear on that, I'm town council. And
Yeah.
I'm just advising you on the limited circumstances under the town charter about a board's ability to select its own council. You're free to look into that all you want. Get your own
Right.
council, do
understand
whatever you
that.
want. It's a free country.
I'm just
You know.
following up on, there are some hairy issues here that John Bresser brought up with, who's the client, attorney-client privilege, and it might be worthwhile for us to explore it.
Okay, well, let's see. Let's move forward with the letter and see what comes of that. Unless anyone if you want to make a motion to look into independent counsel and the board sees fit to do that.
No, that's fine. I think as long as we don't foreclose on it.
Okay.
And Susan, I'm
yes.
not, I don't get to just pick and choose what I work on. What I'm going to do is.
You'll have to speak to Libby, right?
If
to
their
see it.
motion, no, what I'm going to do is immediately following this meeting, I'm going to write you an email saying what that vote is. And if you want me to, and what I'll do is I'll send it to you and I'll copy the town manager.
Okay.
That will be the so-called letter, because I don't want anything being held up because I didn't send over your request.
No,
So
yeah.
I'm just telling everybody that's listening, that's how I'm going to do it. The motion that you just made, I'm going to write it up in an email. I'm going to send it to you, Chair, and I'm going to copy Libby.
Okay.
And then I'll leave it, for interdepartmental communication from
Okay.
there.
That works. Thank you. Okay, so I think unless there's anything else, I don't see anyone's hand up or anything for that. We are moving on to, so number 4 on our agenda was to enter into executive session, but for a different matter, different litigation matter, which we addressed at the regularly scheduled April 13th, 2023 meeting. So that portion of the meeting, we no longer need to address. So I just wanted to, before we adjourn, thank everyone who has signed in and this was longer than I expected it to go, but I think there were some really good questions and good points brought up. I hope everyone on the board feels a little bit better about knowing what's going on now and we have a couple of tasks. One is to, each look at those plans and see if you spot anything that you have questions about and with the comp permit. And we will see what happens with the town. But again, thank you to everyone who signed in and who gave feedback. And George, thank you for giving us the update on Surfside Crossing. Would someone make a motion to adjourn?
I'll make that motion.
Okay, and Michael has seconded. Okay, again, with roll call. Michael O'Meara.
Aye.
Jim Mondani.
Aye.
Elisa Allen.
Aye.
John Brescher.
Aye.
And myself, aye. Okay, so we are now adjourned. George, I'll look for your email. And again, thank you everyone for your time today.
Thanks very much.
Thank you, everyone.
Thank you.